So Meghan Markle might be in some serious legal trouble, and I hate to be the guy that says I told you so, but I told you so, because I did say when I did my little review of her Netflix series thing that when she was talking about the bath salts and experts were saying that, well, this might be literally a recipe for disaster, I said that she might be in some serious legal trouble. So welcome back. Very quick video this evening. We're here on Secrets. Please do subscribe to the channel and support me. We are headed towards 200,000 subscribers. Haters be damned. Thank you so much for that. Let's take a look at what we've got here, because especially for those of you internationally, I don't know how this has been reported further afield, but certainly here it's been reported by the Daily Mail. And there's this potential claim hanging over her now for $10 million or £8 million and a whole lot of medical bills, where Robin Patrick is threatening to sue Meghan Markle, Netflix and Archwell Productions for $10 million, claiming that she's suffered severe burns using a homemade bath salt recipe that she found on Meghan's Netflix show With Love, Meghan. And so what we'll look at here, we'll take a very brief further look at the article here. This says that she sent a letter to Meghan Markle, Netflix and Archwell Productions outlining serious injuries, post-traumatic stress disorder after having a bath with this salt mixture. I was going to, but I won't show the photographs. They are quite horrific burn mark photographs. YouTube will probably limit my video if I do that. But she said that it started out as some kind of tingling sensation and then started to be a little bit more uncomfortable, then started to burn, then had some ulcers, leaving her with some fairly serious burns, about 18 burns, still not fully healed, leaving her vulnerable to infection and all sorts of stuff. So let's have a brief discussion over what might happen here. Now, first of all, the first thing that would need to be established would be a duty of care. Now, I will say that courts are generally slow to impose a duty of care on media presenters because there's no real relationship between the presenter and the viewer, and you can't generally be held on a very broad spectrum responsible for what the viewers do, save of course unless you're encouraging dangerous behavior or you're telling them definitively this is the way something is when it turns out it's not and they've acted on it and so on. And the more that you speak specifically to a particular viewer, the more that they are likely to act on what you've said, the more likely there's to be this duty of care, etc. So the first thing they would have to establish is that there's a duty of care. Now, apparently, their lawyers have already said that no duty of care exists because there's no special relationship and or of that of the producers, etc. And so they are not generally responsible for what viewers do. But let's just say that they say that there is a duty of care there, because I understand that there was a recipe posted later. And so let's say that there was a duty of care established. So that would be the very first step. Now, what we would say here is these are the sort of cases that are very difficult to establish, because first you have to establish this duty of care. In most scenarios where a claim would arise, that would be relatively easy. So let's say you're out in your car on the road. Other road users have a general duty of care to everyone else on the road. If you go and do some work on somebody's house, you have a duty of care towards them because of the way that you're doing work on their house, etc. But in this scenario, there is that disconnect. But let's say that you've established that duty of care. What needs to happen then is you need to establish that they've breached that duty of care. So that will be analysis based on industry standards, whether what they've said, whether what they've done lives up to those standards, or whether they should have had disclaimers, whether they should have had warnings and told people, don't try this at home, kids, that kind of thing. If they do make all of those statements and those warnings, disclaimers, etc., generally that can absolve them of the breach of that duty because they've taken reasonable steps. But even then, let's say that there's a breach of duty. Let's say that they haven't done enough of those things. They haven't said, don't do this. Here's a warner, here's a disclaimer, here's what not to do, seek expert advice before you do any of this, that kind of thing. Let's say then that they have breached that duty of care. So firstly, it's established. Secondly, that there's been a breach of that. There then needs to be, obviously there needs to be damages. This is normally looked at afterwards, but all of this obviously starts with damages. Believe it or not, some people start one of these claims and there aren't any real damages to be said, but they come later. But there has to be causation of those damages. So the breach of the duty has to cause the damage that they allege. So firstly, obviously, they have to prove that there's damage, but they have to prove that the breach itself caused the damage. So it wouldn't be enough, for example, to say that, she went for a bath with all these salts, sort of loosely followed the recipe, but she tweaked it herself and dumped a whole load more salt in, or a much stronger, so it becomes, much more potent, much stronger mixture than was shown in the show. If somebody did all of that, then quite obviously any breach didn't cause that damage because they've gone outside of what was recommended. But if they were to show that they did precisely what was said, and I'm not sure how they'd prove that after the event, if it's been done and it's been used, etc. But if they could show that they did only precisely what was said, there is still this duty then to prove that the breach caused the damage. And there could be all sorts of other intervening factors that break the chain in this causation. And that is one of the things that make these claims so difficult. Think medical negligence. Let's say somebody is already unfit, they're already unwell, or they've already got a heart problem, already got a liver problem, or whatever, and they go into hospital, and there's obviously a duty of care. There's obviously a duty upon the hospital to provide the proper standard of care and so on. Let's say that they don't do that, they fall well below standards, and so there is a breach of that duty of care. Let's say the person is then injured or passes away. Then we have to establish then, did the breach of the duty that has been established, did that cause the damage, or, in the case of personal injury or death, did it cause any of that? Now, if the person would have suffered the injury or would have died anyway, regardless of treatment, regardless if the treatment had been up to standard, this is a very common break in the chain of causation in these kind of medical negligence cases, whereby the claim will fail. And so a lot of these cases, they will establish the duty of care. They might even establish the breach of duty of care. And it's at that point that a lot of people then struggle to realize, well, if there's a breach of duty of care, surely they owe you some damages because you've suffered loss, injury, or damage. But that's not necessarily true if you can't prove that the breach was the causation of said damage, injury, loss, or death. So that will be the difficulty there. And also when we come on to damages, we look at the amounts claimed. Now, in the United States, I noticed that the amounts are usually much higher because you have punitive damages in the United States. We don't have that here. We just have damages, be it general and aggravated damages. But in the United States, they tend to be a little bit higher. But even regarding that, some people may consider that exaggerated, but that's not really for me to comment because I don't know the full extent of the injuries and so on. But then, of course, we come into all the other factors and we consider, was there any parental responsibility here? Was there any other factors such as they should have been aware of their own skin conditions. They should really reasonably have consulted medical practitioners if they did have any skin conditions. They should have taken their own precautions and all of these kind of things. And so ultimately, there's a lot of intervening factors that might stop that chain of causation from progressing for the causation of the damage. But who is responsible? Well, ultimately, it could be Meghan Markle responsible. Netflix and Archwell Productions could share some responsibility and liability. But frankly, I think this is probably quite a difficult case to establish. And so this is probably an uphill battle to establish all of those steps. Those kind of cases they tend to be quite difficult to establish. But there's just a very brief overview. I hope you found that interesting. We're on secrets. I know we've touched on law here, but please do subscribe to the channel for regular updates. And as always, thank you for watching.